want to go ahead at this time and please, a round of applause. I'm going to bring in Doug Weinstein and our friend Rachel Kaufman. Good afternoon, guys. How are you?
Hey, good afternoon, Phil. How are you doing? Thank you for having me on.
Yeah, I know Rachel is also traveling. Doug, thank you for sharing. Both of you guys, thanks for sharing some of your Saturday. Doug is, I call Doug one of the architects of this, but he'll be the first to tell you he's not the only one, obviously, that's working on this. He is the one who got these rulings from the Georgia Supreme Court, and he doesn't have to answer this or speak to it. But what I can tell you is that when you've got multiple co-defendants, the lawyers, where they can, and they can't always because their interests are not always aligned with every other defendant, but where they can, they collaborate, they cooperate. And I would suspect that there's been some collaboration and cooperation from many members of the various defense teams. So this is certainly not something I'm sure Doug is saying is all him, but his name's on it. And Doug, that's why you're here, buddy.
Oh, well, thank you. Yeah, obviously we talk behind the scenes about plans and we don't always agree, but we do always discuss things with each other as to what we're going to do. So nothing's a surprise to any of us. Well, and I don't think any of my co-defendants counsel, they were surprised by this filing.
No, I wasn't surprised either, and I predicted it. So you heard most of what I was getting into here, I'm sure. Did I get anything wrong? Is there anything that you want to add to that so far? Because I do want to talk more about what's going on with your current efforts, because, I'll let you explain it, but I know that the mandamus in Superior Court is still pending. But as far as what we've gone over so far, what do I need to add to any of that?
I don't think anything other than, if I can sum it up simply.
Please.
On the 10th was the ex parte hearing. On the 12th, I filed my motion with Judge Glanville for him to recuse himself. He didn't follow Rule 25 like he was supposed to. On the 12th, I explained to him that I didn't believe he was following Rule 25. He basically said he didn't care and continued to rule against me without going through the proper steps. So on the 14th, he came out with his order, basically making it official that he was ruling against me. But then he did make some of the requisite findings under this Rule 25, all of which were in favor of my client. The next week, I was out with COVID and sat in my bed and drafted this petition to the Supreme Court. I was
wondering where you found the time. I'm glad you
found it. I want to chime in on that. So
yeah, please.
As a sole practitioner, there's not many opportunities where you have a trial that's going on this long, where you have enough collaboration from other attorneys that you can take the time to really check on these rulings from the court they seem unfair as a defense attorney, but you're preparing for the witness the next day. And so what's been happening for so long, and why Judge Glanville, in my opinion, so far has just been pretty flippant about these rulings, thinking that it is par for the course. This is usual, normal behavior from the bench that very rarely gets challenged, because as sole practitioners, if you're trying a case, a lot of us, aren't on these high profile cases where we're being paid enough to really even, we've got other cases, you're juggling a million things and you can't take the time to write. I'm so glad that you did, Doug, because the fact that the judge thought that all of this was just going to go away, that it would all just be fine. That's how it usually goes for him.
Right. Judge Glanville's usual. That's exactly right. And Judge Glanville, he'll say this from the bench frequently, I would say. He'll make a ruling, and if you disagree with him or you think he's made the wrong ruling, he'll say, if I've made the wrong ruling, the Court of Appeals will look at it, they can overrule me, and I can live with that. And that's why I think, Rachel, you're saying it's a flippant attitude.
Yeah.
Well, it comes across as flippant, it really, and look, I mean, we've all tried cases, and look, every now and then you'll hear a judge say that, and that's not incorrect. But when they say it over and over and over again, it's almost like they're saying, I don't give a damn if I get it right or not. Somebody else will correct it if it's wrong.
My main issue with it is our clients are in jail now. If they get a conviction, they're going to be in prison. It's going to be years before an appellate court can rule on this. And while Judge Glanville may be able to live with making a wrong decision, our clients are stuck in prison.
Their lives are
perhaps based on that wrong decision. So, and I should also add real quick, because I don't want to let this pass, Katie Hingerty, who's my co-counsel in this case, she also worked with me on polishing this up, because I am just an old engineer. She's a journalism major as an undergrad. Together we covered it. I think
You know,
we
that
covered it. But
I didn't know
yeah,
that. So when I said we're going to get the inside story, that's really it. So because
yeah,
engineers, I didn't know you were an engineer. Engineers like all the T's crossed and all the I's dotted, and of course journalists are the wordsmiths, right? And so
they are.
together, I think you guys made a great team. I thought it was. I
Thank
think
you.
I texted you while I was gone, or I emailed you about this. I said it's a work of art, and I think it was. It's
Well,
fantastic pleading.
So it can be used again. I mean, you've created a template
Oh
for
yeah.
other attorneys to now have access to a very powerful, mandamus. Most of us wouldn't have the time or brain power to do that on our own. So thank you.
because this case has gotten so much publicity, particularly with the holding Brian Steele in contempt, it has gotten the attention of attorneys not just across Georgia but across the country. And so I had attorneys around the country that were doing independent research on these issues and emailing me cases and emailing little snippets and research they had been doing. Talk about a joint effort of the criminal defense bar of not just Georgia, but across the U.S. Because, as soon as any attorney, any of us, civil or criminal, hears ex parte, that immediately kind of can rile us up, as you said, Phil, I think.
So while I've got both of you guys here, what I want to do is, and I've compiled a list of like video snippets, and I've tried my best to put them in some kind of order, weird things and noteworthy things that have kind of happened in the trial. And so what I'd like to do is just go through those, and it will culminate with this most recent stuff here. And I'd like to, Doug, I want you to kind of give us sort of the inside story on all of these things. That sound like a good plan?
To the extent that I can. I'll probably still say more than I should, but not as much as Rachel will.
No,
be
I don't.
happy to
No,
say.
you're not going to say it. But see, some people
I
have
gotcha.
questions that I can't answer. Like, what is the relevance of this piece of evidence and all? You're in a better position to know that than me. So let's just give it a shot. So here we go.
Man, can I get a water or something? I'm so high right now, y'all. I'm about to go to sleep on y'all now. I ain't gonna tell you no lie.
Yes, you may. We're gonna take a break soon. Hang in there.
All right, so that was towards the very beginning. This is after a year or so of jury selection. We've played this video countless times here. We refer to that as the high guy, and so we've discussed this in the context of contempt and everything. And when a witness shows up intoxicated, people's lives, like your client's lives and his freedom, is on the line, and the state's calling a witness like that. First off, I mean, how do you react to that in the courtroom in real time when knowing this is a state's witness? They've called this person as part of their effort to send your client to prison, and the witness shows up intoxicated, and the judge doesn't do a damn thing about it, lets him testify.
I can tell you that myself and some of the other counsel, I didn't realize he said hi in real time when I was there. I didn't hear hi. I heard tired. I guess because you're not expecting a witness to say that they're high.
Welcome to
What's
Atlanta.
that?
Said,
Yeah, I
welcome
know.
to Atlanta.
I know, right? So I actually, saw some of the comments. I went up to Christina Weaver, the court reporter, to try to figure out what he said. And I don't remember if it was at the end of the day or before the end of the day. Re-listened to it and like, oh my gosh, he did say hi. And how do I respond? Well, it's one of many, many of the prosecution's star witnesses who really don't want to be there and who don't testify the way that the prosecution is expecting them to testify. I let the jury assess whatever credibility he has based on him being high, I guess, on the stand, as he admitted.
Well, to me, I think it's shameful for a prosecutor if that's state's evidence, that's part of their testimony, part of their case against your guy is based on that. I mean, we can laugh about they call him Mr. Bean and all that. We can laugh about this a little bit because it is kind of funny, but it's not really funny if you're the one who's standing trial for this. I'm going to move way ahead in the trial now.
See, our jury has left us. Mr. Copeland, given the fact that you have invoked your Fifth Amendment privilege, but the state has already given you immunity under 24-5-507, this court holds you in willful contempt, and we'll see you on Monday. And we'll see if we can get some more testimony at that point in time. Take him into custody.
There it is. So that's when Copeland, Lil Woody, goes to jail. I think that was on a Friday. Doug, what was it like in the courtroom when that happened?
I was pretty pissed off when that happened. I think we were all upset. You don't want a witness taking the fifth in front of the jury. I think the judge had worked to avoid that by going through the questioning with Mr. Copeland in that morning, Friday morning, before the jury came out. He eventually decided that he was, I think his attorney was Mr. Melnick then. He eventually decided he was going to testify. Then at the lunch break, Mr. Copeland was out in the hall. There were investigators around Mr. Copeland. Mr. Copeland is on the phone, loudly telling whoever he's talking to that he is going to take the fifth and he is not going to testify. The investigators are part of the state. They knew about that, and they put him on the stand anyway. And I'll let Rachel say what she thinks about that in terms of these prosecutors.
So again, this is standard operating procedure for the Fulton County DA's office. I have a case on appeal. It's a Glanville case. Oftentimes, the prosecutor's office, through their investigators or through the prosecutors themselves, will actually approach an individual who they know to be represented. However, they claim because of the situation, they had to find him or they had to call him. They could have called the lawyer. They intimidate them privately. And even if they know that they're going to take the fifth, they think that doesn't help the defense, that technically would help the state, because it seems as though he has information, but he doesn't want to participate in telling it. That really cannot go before a jury, because it leaves the door wide open as to what he means by that. They're not supposed to put somebody on the stand, even if they've been guaranteed immunity. If they know that they're going to plead the fifth, it should be handled outside of the presence of the jury.
All right, so for the lay people that are watching this now or in the future, Doug and Rachel, I guess start with Doug, and then explain why it is that when you're representing, why would you not want him to take the fifth in the presence of the jury? Because that might not be obvious to everyone.
Well, it's exactly what Rachel said, especially in this case, because the prosecutors have been weaving this story that witnesses are changing their story on the stand because they are afraid of our clients. There's no evidence for this. There's no evidence that our clients have threatened them in any way. None. But they are weaving this story in front of the jury, and then they put a witness on the stand to take the fifth.
Right.
And they are definitely doing it to imply to the jury that they're taking the fifth because they are afraid of our clients. And by the way, if you watch Mr. Copeland's social media, does that look like a man that's afraid?
No. And that's the irony of all of it as well, is that these people that they're calling to the stand, Mr. Bean, high as hell, and then you've got Woody, Kenneth Copeland. I mean, these are individuals who, in a different setting on a different day, the prosecutors would be going after for whatever they've been doing. So it's so fascinating how they just excuse all their behavior, all their lies, their unwillingness, their lack of cooperation, their changing of stories, and they kind of frame it to benefit them. But any other day of the week, I mean, these guys are just as problematic, if not more, than the individuals that are being tried. So when they plead the fifth in front of the jury, it creates a situation where the jury is wondering and is left to kind of make implications and assumptions for themselves about why they're not willing to participate, and that really cannot go forward. I remember Brian Steele bringing it to the attention of the court that he had heard earlier that day. He had heard Kenneth Copeland on the phone saying this, and the judge is screaming at him, saying, "Why didn't you tell me? It's your duty to tell me." It's like, okay, I was not the one calling him as a witness. The state heard this too. Why are you not yelling at them?
Well, actually, I'll hold that for later. We're gonna talk about what we now know happened in that ex parte, but I don't want to get ahead of myself. So right about the same time, right? So Copeland goes and says he's going to take the fifth, and he gets thrown in jail because the prosecutors have given him immunity. And some of the questions in the chat, even before we started, people were asking, how is it that prosecutors can give somebody immunity that they don't want? The answer that I've got is that, well, they just can. And once they give you immunity, theoretically, you don't have the right to, your words cannot then incriminate you because you've got immunity. Therefore, you can't claim the fifth. But in this case, there was an issue about the scope of that immunity and it not being broad enough to cover potential federal charges. So in my opinion, he still legally could have taken the fifth. But there was a kerfuffle between Jonathan Melnick, who was Copeland's original lawyer, an ADA love that resulted in this.
And for an assertion to be made that I or Mr. Copeland are somehow being influenced by somebody over here is absolutely ridiculous. I take great offense to it, and I can tell Ms. Love that I am going to the state bar to report her for contacting a witness that she knows to be represented by counsel. She and I have had conversations about Kenneth Copeland.
Oh, she's
All
a
right.
devil. That's all.
And so this was, I think, around that Friday afternoon. Correct me if I'm wrong, but that was around the time that he being Copeland was thrown into jail for contempt. Melnick was getting ready to go, I think, out of town. It's my understanding it was like a pre-planned kind of thing. And people are saying, well, the state is wanting to imply that Melnick was doing something improper because they're saying, well, he told his client, I'm going to withdraw if you don't take the fifth. But let me tell everybody that there's a better, more reasonable explanation for that, because if a witness, if you have a client who's a witness, or if you're representing somebody in a criminal case and they want to take the stand for themselves, a lawyer cannot participate in perjury. It's called subornation of perjury. We have an ethical obligation not to be part of it. If Melnick believes his client is going to take the fifth, that's one thing. But if he knows that his client is going to take the stand and lie, he has to withdraw. He has a ethical obligation to withdraw. Am I wrong about that?
I mean, that would be a good reason. I also just want to say there's some chat in the chat about Kayla Bumpus and her not taking issue with Adrian Love. You guys also don't have to say anything about, I mean, I don't know how Kayla Bumpus got involved in this case. In my dealings with her, I don't find her particularly professional. I'm glad that she provided information, but if she thinks that Adrian Love is a good attorney or is unproblematic, I mean, that just confirms what I thought about Kayla Bumpus.
Well, I don't know what she thinks either, but it's my understanding she was brought in because, see, Melnick, Doug, and you may know more about this too. Feel free to correct me if I'm wrong, but see, Melnick had plans to go out of town. I mean, and so what he did, like all of us sometimes have to do, and even I had to do when I was gone this last time, you've got to sometimes pay or hire or otherwise arrange for other attorneys to handle things that you can't get rescheduled. Okay. And so this is a thing that it looks to me like Love and perhaps others on the team knew that Melnick had plans, and they timed this witness's testimony to bump up against his known travel plans. It seems to me, because I'm a cynic, maybe there was some coordination there, but in any event, Melnick had to bring in another lawyer to cover for him.
That's not who
I think you give the state far too much credit in their ability to plan for that.
All right.
I have not seen that kind of skill level exhibited by the state, so
Yeah.
I don't think that's the case.
At the end, I'll tell you a quick story about Kayla Bumpus because it's important.
But she was brought in by Jonathan Melnick to cover for him because he had plans. He tried to explain it to the judge on Friday without doing it in open court, and the judge refused to let him. Jonathan Melnick in open court had to explain that he had a non-refundable airline ticket,
which is fine. We've all been there.
Yeah, we have.
And so courts, attorneys file leaves of absence, which under the rules are supposed to give you, for lack of a better word, immunity from having this kind of thing pop up. But sometimes judges don't always honor leaves of absence.
But there was a lot of problems here just because, as you heard Mr. Melnick complain about, the state was basically bypassing him.
And that's what they do. They'll be like, whoops, we didn't mean to. We knew he was represented, but we had an opportunity to talk to him, so we took it. I mean, they're not used to any consequence for doing so. So they do it.
Are you telling me
somebody
that Fannie Willis's office takes liberties with ethics and practices and in a way that is unfair and doesn't follow the law? Surely you can't be saying that about Fannie Willis' office.
And ironically, they also are the ones that pled the fifth when we were trying to get to the bottom of Fannie Willis's relationship with Nathan Wade, and they're pleading the fifth left and right. So it's just funny how they try to imply in these other prosecutions that they're handling that it somehow means that they're being intimidated. But when people that are being called and subpoenaed in the case against her, that's not intimidation.
Oh, wait for the inevitable onslaught of Willis motions about your cell phone geolocation data not being an accurate reflection of where you are.
Well, I mean, obviously the DA's office uses that every day, the cell hawk stuff in prosecuting people, particularly in drug cases. And there's a lot of them, obviously, in the system. So her words may very well be used against her. Let me show you this one clip, Doug, and I'm going to tell you, explain to us what this was about.
Text message. I don't recall any conversation with Detective Thorpe.
I'm saying you can slow it down, but I'm gonna keep asking you these questions. So, do you recall texting or telling Detective Thorpe that so another guy called you and said that those people were just lying?
I don't recall.
What was that all about, Doug?
He was just so frustrated because, of course, what Hilton was trying to do is lay the foundation for her to try to bring in all of his interviews. So she just was stepping through over and over again his prior, I guess, things that would be inconsistent with his prior testimony, and getting him to say, "I don't recall." And he was just exhausted and tired. And I mean, I don't know if you're going to play the clip where he just says yes to everything, but at one point he does that as well. And then ADA Hilton says, "Are you just saying yes to get through this?" And he's like, "Yeah, that's what I'm doing."
And that's their star witness,
That is their superstar witness. This
They're
is their
basically-
number one witness.
They ate it up and didn't really fact check anything. And then we're hoping that they could build a whole RICO case based on what this one guy was singing about one day.
Before we move on, we got more to talk about. So real quick, Doug, who is Copeland and where does he fit in this whole thing? And why is he the star witness? Because a lot of people aren't fully understanding who he is and where he fits into all of this.
Copeland was friends, acquaintances with a number of the people that are named as defendants in this RICO case. According to Copeland, according to his prior interview information that he gave to the police, I think it was his 5th or 6th interview with the police after the murder of Donovan Thomas. So Donovan Thomas was murdered. There's an interview of Copeland, like the 5th or 6th interview of Copeland in June, where he says that night of Donovan Thomas's murder, he went to a McDonald's over on Cleveland Avenue. And at that McDonald's, someone got in the car and said something to the effect of, "Those guys just shot Nut." Nut is Donovan Thomas's nickname, Peanut. So this is where Copeland comes in as the star witness. He heard somebody say that they heard, I think, that those guys just shot Peanut. So you've got a couple of layers of hearsay. Anyway, this is their superstar witness. And it was 9 years ago. He told the cops whatever they wanted to hear. You'll hear him say this at times where in his police interviews. He doesn't want to wear that blue jumpsuit. He doesn't want to be at Rice Street. He'll say whatever he needs to say.
Yeah, Rice Street, by the way, is
Rice
Fulton
Street.
County Jail.
Yeah, nobody wants to be at Rice Street. It is an inhumane place.
Yeah, which is part of the coercion. That was part of the problem with the ex parte communication, is that they're not telling him he's going to be sitting in Cobb County Jail. And you're going to sit in Rice Street, Fulton County Jail, for as long as it takes to get all these people tried, which, given these are 6 of the co-defendants, and there's still other people that are still awaiting trial. So that could be years, and people are dropping dead like flies. So,
all right. So
yeah,
building
read
up
that transcript. Read that transcript.
So moving along up, this is where I think this is at least one of the times when I think it was obvious that the heat started really, really getting high in this trial.
And I know that they did know that he was going to take the 5th because I heard it said outside right before I walked into court. I even said the officer.
Then why didn't you, as an officer of the court, tell me before we took his testimony?
I told Mr. Steele.
No. Why didn't you, as an officer of this court, tell me?
Well, then that's my.
I got a problem with you now.
Well, that's fine. I mean.
I got a problem with you now.
Well.
I would suggest you don't say any more.
I've already said it.
I know that, sir. And the problem is you should have told me if that were your case, then you just made an argument we didn't even need to have, because I could have certainly asked him based upon your proffer. Now you want to have it both ways. You can't do that.
Your Honor, I thought the state knew that. And
that's not what the point is. The point is, you as an advocate, is you should have told me. Both sides have an equal responsibility under the rules of professional responsibility.
Okay, as long as we're both responsible, that's fine.
All right, have a seat, sir. Thank you.
So I'll go first, and I'll let y'all go. But before I forget, it strikes me that first off, Glanville is really quick to have a problem, using his words, with the defense lawyers, but not so much with prosecutors, even if they're equally culpable. And I'm not saying that they are. What the lawyer was referring to was the same thing, Doug, you were talking about, was this Copeland was out in the hallway basically telling God and everybody that he was going to take the fifth. So it was not exactly uncommon knowledge, right? And so the judge he won't let anybody finish his sentence. He's hot-headed. He's quick to get really, really angry and just fly off the handle. But anyway, that's my opinion. Doug, what do you think about that?
Okay, I don't agree with your assessment of the judge. I think some of that is just what gets often shown. He tends to be rather cool, but I will say that he can be quick to temper. But most of the time, he keeps it in check. It's exactly what you're saying, Mr. Botts, an esteemed lawyer who's been practicing forever and ever and
he's
ever.
the nicest guy in the world, by the way.
Nicest guy.
Big fan.
He's been practicing forever. Mr. Botts gets yelled at, not the state whose witnesses it was, right, Rachel? That's the state's witness.
I take issue with the fact that he says it's both of your responsibilities. We all need to go, everybody in that courtroom, specifically the state, but I would be happy to be there and go over it with everybody, the rules of professionalism and responsibility, because everyone seems to have lost their way. There is no guiding light or North Star. And we're just saying it's not my responsibility as the defense attorney, if I know that the state has heard that he's going to plead the fifth, to tell the judge when the state they're calling the witness. It's their witness. They know he's going to do that. They have a duty not to allow him to do that. Why is that my responsibility? And I would be concerned that if I tried to mention that before he got on the stand, the judge would bite my head off. I mean, I also think he does lose his cool, but he's generally been okay before, but he just will sometimes just snap at people. I feel like it's, you're mad at one dog and there's a dog closer to you, so you just bite that dog.
It feels like we tend to catch the brunt of it. And again, I refuse to see this for most of the last 18 months until that ex parte hearing, but I have to go back and reassess. Yeah. It just seems to me that if we would behave the way that ADA Love behaved in court, the judge would tear us apart.
She gets this woman, and I've been on cases that are less publicity, way less important to the average person. I've been screaming from the rooftop since about 2016 what a monster she is, how unreasonable she is, how she gets away with everything. And the fallout from that, it ends up being on our clients. I care about justice. I believe in fairness. I believe that there should be accountability where it's due. But the lengths that she will go to win create a situation where the truth doesn't matter and justice is not served when she's in control. That's how I feel. And I've known it. And it makes me very upset. And seeing it on this main stage, I love that other people are seeing it too. And if Melnick isn't going to file a bar complaint, I don't know if my issues with her are still ripe. She has done monstrous things to innocent people. And I can say that with a straight face.
Also, I want to say this about all this recusal business and petitions for writs of mandamus and everything. I don't want to lose sight of my main goal here. And I think the main goal of all of us, but I don't want to speak for any other attorney. I just want a fair trial.
Oh, yeah.
Give me a fair trial with this evidence that they're presenting, and we'll get not guilty verdicts. Just give me a fair trial.
I'll say this before I move on to the next video clip, because I do want to get into the current posture of the case. Those of you who are familiar with this channel, who've been in here before, or if you're new, what you need to understand is you will very rarely, if at all, hear us talk about somebody's guilt or their innocence, unless we're discussing a verdict or something along those lines, because that's not what this is about. The whole point of all of this is we are learning how sometimes trials can become unfair. And we're seeing it in this case on full display for the world to see, because we've got live streaming now and other things that open up courtrooms to the world. But we three attorneys here and all of our colleagues, I mean, those of us who are in these courtrooms day in and day out, we see things like this happening all the time. They just don't see the light of day. There's some things here that are pretty extreme, but to some degree, we see things like this all the time.
They're ex parteing all the time. They seem to think it's okay. They seem to not think that there's anything wrong with it. They're not even scared to get caught in it.
All right.
That's
So
bizarre to me.
So Woody's he's taken the fifth. Copeland, he's taken the fifth. He's been carted off to jail. Monday morning, we expect him to come back and start testifying, right? But what's happened is there's been a delay, Doug, right? It was a couple of hours, and y'all didn't know what was going on, but we had this ex parte thing going on in the judge's chambers, right? That's how it happened, okay?
Apparently,
and so then
so.
Brian Steele makes an issue of it, and he says, Judge, I want you to tell me about this, and this is what happened.
I'm doing that at this point in time. So you'll have a choice to make. All right. Take Mr. Steele into custody, please.
Your Honor, would the court afford me one moment to confer with counsel regarding the appropriate remedy in this type of
Okay. All right.
May I say one thing, Your Honor?
Yes, sir. You certainly may. Mr. Williams does not wish to go forward without me being here. You are removing me against his will, my will. You're taking away his right to counsel. And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial. And I assume you deny, but I'd like you to deny our motions for mistrial. You denied the other people. I've denied your motion, but I'll certainly take that under advisement, sir.
All right, so that's when he found he held Brian in custody. By the way, you won't find a nicer lawyer, just a great all-around gentlemanly guy, soft-spoken, one of the finest criminal defense lawyers in the state of Georgia, in my opinion. You won't see this every day where a judge is trying to throw him in jail. For what? Because he dared to question Judge Glanville on what he was doing back in his chambers that was improper, that all of you guys, Doug, should have known about. You should have been able to object to it. And hell, you should have been able to participate, okay? Because it shouldn't have happened in the first place. But instead of Judge Glanville being worried about what Glanville had done wrong, he gets mad at Brian Steele because Brian will not disclose to Glanville how Brian, learned of the ex parte.
And the analogy is that you accuse somebody of cheating on you and they ignore the fact that you've accused them of that. Who told you?
Yeah, right. That's exactly it.
It's like you cheated on me.
Doug, what was it like in the courtroom? I mean, it must have been surreal.
It was intense. It was distressing. I was shocked that the judge was clearly trying to divert attention away from the meeting to, again, the cheating analogy is perfect from Rachel. How did you learn about this? Brian and I learned about this along with one or two other attorneys during lunch. How we learned about it is not important. Exactly. That's not the issue. The issue, and it's kind of a shame that so much got focused on Brian Steele being held in contempt, as outrageous as that was, because that's terrible. But it kind of accomplished, at least in the short term, the judge's goal, because it diverted attention away from the ex parte to Judge Glanville holding Brian Steele in contempt. And Rachel, I'm sure you'll third what Phyllis said, which is there's not a more professional lawyer in the state of Georgia who dots the I's, crosses the T's on ethics and professionalism than Brian Steele, on top of being a phenomenal advocate for his client.
He knows more about the law than, he's got enough law in his brain. I love when he handles the appeals and the state's arguing about a case and he's like, I actually handled that case and that's not what it said. He knows more about it than anybody else, highly respected, was not remotely disrespectful to the court. Again, it reminds me of the cheating. It's like, you went through my phone. I'm going to hold you in contempt for going through my phone, except for you're texting. Yeah. You're sexting other women. What are you doing? You're right. It's just a complete, I don't know what the right word is. It's a complete defense tactic of like, we are going to completely ignore what I did. I'm going to start blaming you for something that's not even a problem. And the actual consequence is sending him to jail.
Rachel, what did you think about ADA Love jumping in and said, let me confer about what appropriate remedies might be on an issue between Judge Glanville. This is an issue between Judge Glanville and Brian Steele. And then she wants to weigh in.
You don't decide what the consequences are because you're not the judge. That's what I was saying. I don't know who she thinks she is, that she would, let me confer, because what? She decides whether or not the judge holds somebody in contempt. That dynamic, the dynamic where she thinks that she has power to decide what the consequences should be for Brian Steele. I mean, what planet are we on? It's not the law that I learned. I'll tell you that.
I just had to pitch that softball, Rachel. I couldn't comment on it, but I knew she could. Oh my
God.
All right. So based on all of this, Doug swoops into action here, because at this point the trial is totally out of hand. And if there was not reversible error at this point, certainly there is now, and things are really getting out of hand. So, Doug, here's your motion to recuse.
My attention, Mr. Weinstein, you filed a motion to recuse me. You filed an affidavit consistent with that, pursuant to Uniform Superior Court Rule, I believe 25.2. The court's had an opportunity to read your motion. I've also had an opportunity to take a look at, because this issue comes up a fair bit, Baptiste versus the state. I'd invite you to take a look at that, and that's from our Court of Appeals, 229 Georgia Appeals 691. Basically, you can't file a motion to recuse for ruling that a trial judge makes, okay? And that's what you're doing in this particular situation. You're saying you don't like what I ruled upon. You're alleging some facts in an affidavit that support that decision. Because if that were the case, then no trial judge would be able to sit through a trial and give adverse rulings. So for the reasons set forth in Baptiste and other cases, I'm going to deny your motion to recuse on its face, okay?
Your Honor, may I just address what you said? I disagree with your characterization that I filed a motion as a result of any ruling.
No. Well, you did in your affidavit. I'm taking in your affidavit as face value, okay? All right? I'm not contesting where you got the information from, at least not yet.
Yes.
But I'm just saying that because it also encompasses that I made a ruling. And as a result of that, if I make a ruling and you don't like it, then every litigant will say, I want to recuse you, Judge Smith or Judge Glanville or Judge whoever, okay? So part and parcel of it is that's why I'm making my ruling in this particular case. Remember, bias. I've got to do something extrajudicial, and you're in your particular, like I would have to say something about you or your clients or anything like that, which I would never do because I'm a steward of this particular process. So I understand what your objection is, or what your statement is in terms of your motion to recuse. I'm going to deny it.
And I believe, Your Honor, that under Rule 25.3, that you have to cease acting right now.
No, I don't.
And then you can, if I can just finish, and then I promise, if I can just finish this. I believe you have to cease acting. I believe that under 25.3, you have to look at the timeliness of the motion, and you have to look at the sufficiency of the affidavit. I do not believe that you are permitted to just simply deny without taking those steps.
Is that it?
Yes, it is, Your Honor.
Okay. All right. So noted.
Are you denying at this point?
I'm still denying your motion, okay?
Would you grant it?
So literally, Doug, look, everything you said, Doug, was right, and literally everything he said was wrong. I don't know how much more I can say about it, except I want to point out that as you said to him in court, this is not about me disagreeing with any rulings that you've made, Judge. This is about what you did. It's about your conduct. You're the one that had the ex parte. You're the one that violated the canons of judicial ethics, not me. I'm calling you out on it for what you did, not for your rulings. When you pointed out to him that he's supposed to stop right there and he just blows past that and ignores it, my jaw hit the floor.
Yeah, well, and that's the thing is let's just say, again, you're in a trial, you're a sole practitioner trying a case. I mean, if you're not a completely strong, competent attorney with your law ready, it's intimidating to have a judge look at you and try to cut you off every single time you're trying to make the record. Doug is trying to make this record to explain to him, since he doesn't seem to want to read the affidavit or follow the law, what the law is, to make sure that the judge understands what the law is and is still denying it. And every step of the way, he's making it uncomfortable for you to even create the record. And a lot of attorneys, and this is why it takes a lot of guts to be a criminal defense attorney, to be able to say in your own head, like, I'm standing with what I know to be the law and true. And Adrian and all of her little table of goons over there can sit there and shake their heads while I'm doing it. And the judge can look at me like I'm crazy, and I'm still going to say it because it needs to be said. And you're right. That's the whole thing. The whole room's like acting like you're wrong. You're right.
Thank you. Thank you. It was not difficult to get up there because you argue things. Maybe you're right. Maybe you should be right. Maybe it's 50-50. Maybe it's losing and you could this was clear. This rule 25 and the behavior of the judge, the whole thing was crystal clear. There's set steps he's supposed to take. And I actually, as I stood there, I was in shock. Because I thought, okay, it's black letter law, exactly what he has to do. And he hasn't done any of this.
And it's literally right there in writing. We've gone through it before. Speaking of black letter law, there it is right there. It's not hidden from anybody. It's easy to find. You gave it to him. You cited it in your motion.
And how can you tell me to my face that my affidavit was about a ruling?
Yeah,
because I do agree with him. If it was about a ruling, it would drive things to a standstill if we got up and tried to recuse the judge, disqualify the judge every time we didn't. There's been scores of rulings that we've disagreed with, and I'm sure scores of rulings that, maybe tens, that the prosecutors disagreed with in the end. But I haven't complained about any rulings. This was not about a ruling. It's about conduct, and that's why, I don't know if y'all talked about it before, Lester Tate's affidavit that he provided to me that I used in my Supreme Court petition was just gold.
So I want to hold that thought because I want to get there. Okay, we're going through, because what you've just done is you filed, that's one of a few motions to recuse. The other one that's worth mentioning real quick, this is less than a minute.
This is being filed, and it's going to serve state and the court. But it's being filed as well. This is not a filed copy. Just a courtesy copy.
That's Brian Steele. At the end of the day, one day, right around the same time you did, I forget what day it was, he's filing a very similar, on the same grounds kind of motion to recuse. I think one of the ones, there was others, I forget how many, Doug, but those were the two big ones that come to my mind. So the judge summarily just denies all of those, like we just saw in the video of you. You guys are trying to figure out, okay, what do we do now? What's next? Okay, so then comes the idea of the mandamus, and this is where we started the show. So you guys filed a mandamus with the Georgia Supreme Court. I surmise that maybe the reason you did that is you thought it wouldn't make sense, because if you filed it in Fulton, it would go to Glanville. But tell us what was the thought process and how did that come about?
Yeah, I can give you a little background on that so we argued for recusal on the 12th. He denied it from the bench. On the 14th, we got a formal order. That was a Friday, the 14th. An order denying from Judge Glanville. And in that order, interestingly enough, he checks all the boxes where he is supposed to now send it to another judge to determine recusal. But in that order, instead of stopping there, which he should have done, he kept going. And he makes the ultimate determination that he should not be recused. Let me try to say this nicely. He said, I've read your affidavit, but there's insufficient evidence there. Well, to the degree there's insufficient evidence, it's because you won't give us the transcript. But putting that aside, that happened on the 14th. Friday the 14th, he gave us that order. So I immediately over the weekend began working on a petition for a writ of mandamus. And then it was a matter of deciding, do we go to the Supreme Court or do we go to Fulton? And we learned that while it was a very outside chance it would be granted by the Supreme Court, They could grant it. They do have original jurisdiction over that. 2 other petitions for writs of mandamus relating to this case had been filed in Fulton last summer. They went to Judge Glanville, and they've just sat there. They have just sat there. And they're for return of a significant amount of property that was seized at Jeffrey Williams' house that belonged to a jeweler. It wasn't Jeffrey Williams.
And that's Young Thug. We said those are
yeah.
It's essentially a civil forfeiture case, but it's related to all of this.
That's exactly right. So we thought, well, look, if it goes to Fulton, it's just going to end up with Judge Glanville. We need to take a shot at going to the Supreme Court. Worst case, we get a 1-paragraph denial. Best case, they say, Judge Glanville, you need to give this to another judge to decide recusal, as you should do under Rule 25. But most likely outcome that we anticipated is exactly what we got. That was, in a way, the best case, which is the Supreme Court saying, yeah, you really shouldn't go to us first, but here's how you should do it. Yeah. And by the way, here's some subtweets in a way about what we think is going on and how this should be handled. So
yeah, I mean, it's those footnotes, right?
Those footnotes that you highlighted are key.
So I don't know if are we going to get to practically what's going to happen with?
We are.
I have a lot of thoughts on that.
All right. So the Supreme Court, for the reasons that we went over in the beginning, they sent it back. You filed this document, this mandamus in Fulton County. And what happened when because normally, correct me if I'm wrong, but I think the rule is they normally go to the chief judge, right? Which is Glanville.
Normally they would.
But since you're seeking a mandamus and he's the named defendant, I guess for lack of a better word, in the mandamus, it's got to, like the Supreme Court said, it would have to go to another judge, just like a recusal has to go to another judge. But in this case, the mandamus would have to go, not because there's a rule that says it, but because his name is listed as the, I guess, judge you're complaining about.
Yeah,
so it would be a conflict of interest for him to hear his own mandamus.
Right. It's a civil case, and it would be a conflict, and the Supreme Court made that clear in their ruling that they gave us on that Thursday, and we filed in Fulton the very next day on Friday.
So, all right, so judges are supposedly randomly assigned. We refer to that sometimes as wheeling of cases or cases being put on the wheel. I don't think there's an actual wheel that spins like a roulette wheel, but it's that idea is that it's a random assignment. I guess it's done by computer at the clerk's office, right? So what happened with this case? By that, I mean, what happened with your mandamus that you filed in Fulton Superior Court?
Yeah, well, now we're getting technical and complicated, but it did end up getting assigned to a judge within Fulton, as you would expect. And then that judge, Beverly, I'm skipping out on the last name.
It's Rochelle Krause, I thought, or Rachel Krause.
No, that's a different issue.
Oh.
So there was the petition to the Supreme Court. It gets denied 1 week after we file it by the Supreme Court. The following day, we file a petition in Fulton, as the Supreme Court recommends. So we filed a very similar petition that we filed in the Supreme Court, we filed in Fulton. The difference being that the Fulton petition highlighted the language from the Judge Peterson opinion from 2 days prior about the dangers and the problems with ex parte meetings. And it also highlighted the Supreme Court's opinions, because I wanted to make sure
that Edwards, they're saying?
Belinda Edwards. There you go, not Beverly, Belinda Edwards. So Belinda Edwards got the petition we filed Friday. She, within 2 business days, recuses herself. Now that petition is still pending in Fulton. It's a civil suit. So for that suit to continue, we have to serve Judge Glanville. And I had plans to serve Judge Glanville, but what happened is, what did we ask for in that petition? We asked for Judge Glanville to hand the recusal issue off to another judge. We asked that Judge Glanville release the unredacted transcript. And we didn't ask in Fulton, but we did ask at the Supreme Court for the case to be stayed. So we filed that on a Friday. What happened the following Monday? Judge Glanville from the bench gave us everything we asked for in the petition. And by the way, it's everything he should have done June the 12th. But he gave it all to us on July the 1st. So I'm not going to continue to pursue that petition because we already have been granted by the judge all the relief that we requested.
Yeah, and that was what I was going to get at. So you don't have any particular additional need for the mandamus because the judge has already done what you asked for in the mandamus. So now we're left with the recusal.
The energy it took to get what you were supposed to get.
Yeah.
Unbelievable. It took the formal motion, but then after, which should have been granted, but after that, 2 petitions, which took a huge amount of time. The first one in particular, I sat in my sick bed. It probably took me 40 hours plus, and that's not including work that other people voluntarily contributed to draft that petition. And just as Rachel said, what sole practitioner has time to do that in a normal case? If I wouldn't have gotten COVID, it would have been another week before I got that petition the Supreme Court filed.
All right, so the mandamus is now moot, M-O-O-T. It's moot, meaning we have no further need for the mandamus. He's done what you wanted the mandamus order to achieve. He did that voluntarily. I called this the checkmate moment, and it's worth, for those of you who were not here at the beginning, it's worth showing again. Here it is.
Then transitioning to the last matter the court wanted to put on record. Upon further review, this court will in fact enter an order sending Mr. Adams and Steele's, Mr. Weinstein, and Mr. Banks' motion to recuse to another judge pursuant to Uniform Superior Court Rules 25.1 through 25.7 in the method and manner prescribed by our local rules. So this written order is entered. I will enter the order transferring it. And until such time as those 2 things are decided, then we'll be in recess until that time. And we will just inform our jurors that they're until this is, they're not supposed to come back on Monday until Monday anyway. So I will have Deputy Ingram and Ms. Umana indicate to them that they are still on recess and we're continuing to work.
All right. So when I've said on Twitter and here and elsewhere that you guys have checkmated Glanville, he knew it, and that the writing was on the wall. So he went ahead and just did what he should have done in the very beginning. And he is now following the procedures set forth on recusals. He sent it to another judge, all of them. What judge wound up with the recusals?
Judge Krause.
Okay.
Right, Rachel?
Right. That's what I didn't realize that Judge Edwards had gotten some of them, but what a weird position to be in. And that's what politics and power factor into how a judge is going to rule so much more than it should. You know, she's not just weighing, she's weighing her own career.
All right. So we've got another Fulton Superior Court judge now in the position of deciding whether her chief judge and colleague on the bench, Judge Glanville, needs to recuse himself for committing an egregious ethics violation. That's basically where things stand. And so Ashley Merchant and I were talking about this the other day, and she wouldn't mind me repeating this because it's kind of basic. We just kind of assumed that, maybe the Fulton County bench would recuse itself because they're basically having to sit in judgment, if you will, of one of their own, and that didn't happen.
Right, and Judge Edwards recused from the petition for writ of mandamus. I was kind of expecting perhaps Judge Krause to do the same. She may believe that she has an argument that she doesn't have to recuse. We're going to see. What happened was I filed this motion to disqualify the Fulton County bench,
which is what I've got on the screen right now. And
that makes sense.
But the case law is pretty clear. It's real short. And I cite this Georgia transmission case and also JQC, the Judicial Qualification Commission.
Yeah, so let me just cover that real quick. Based on guidance by our Court of Appeals and at least one opinion of the Judicial Qualifications Commission, it is, quote, it is inappropriate for any trial court judge to preside in any action wherein one of the parties holds a judicial office on the same or any other court which sits in the same circuit. And you cite Georgia Transmission Corp v. Dixon, which is a civil case from 2004. That opinion cites the Judicial Qualifications Commission opinion number 220, the JQC being the state agency that can kick judges off the bench. So that's basically what your pleading here is all about.
And Judge Krause has a great reputation. I'm sure she'll do her best to come out with an opinion if she keeps this. I don't know. It's terrible that she has to be in a position to do that with another colleague that sits in the same courthouse that she's in.
And that's been there a lot longer than she's been there on the bench. And so I think that like your friendships, I mean, it's like asking a police officer to say that another police involved shooting was not justified.
Yeah.
They protect each other in the same way that prosecutors protect each other. And so, she's having to think to herself, it just could have.
It gives I think the better practice, even if she, even if there's some wiggle room where another judge in Fulton County doesn't have to, step away from this recusal issue, maybe it's just still the better practice because it just looks bad. And it's just one more thing for people like us to go online or go on TV or whatever on social media and point to. The better practice, in my view, would be to send it out, let another judge from another circuit, another county that's not a direct workmate of Judge Glanville, right?
Yeah, it's pretty obvious that he needs to not be on this case anymore.
Let a retired judge maybe from someone come in, but other judge, a truly neutral, nobody can question their neutrality or objectivity, right? So you just got to get rid of that issue.
Yeah, and that's why I filed that motion, and we'll see what happens with it. I'm not going to get into it too much. And by the way, that motion, just to be clear, that's a motion from Diamante Kendrick's attorneys. I'm not speaking for Brian Steele, Keith Adams, or Mr. Williams, or Gabe Banks, who has the other recusal in. Their positions could be different than mine.
Yes.
Who's Gabe Banks representing?
He represents one of the people that was
messy.
One of the people that Judge Glanville was going to haul in to show cause based on trying to investigate who was the source of the leak. Basically, he ordered all these people to come in, and that's either going to go away or it's at least on hold for right now.
No, he's withdrawn that show cause here.
Okay, good. I was going to ask you what the status of that was.
I hope so. Who told you?
Yeah, he wanted to conduct his own Star Chamber inquisition as to who dared violate the sanctity of my inner chambers, that kind of thing. He kept saying that he had some kind of privilege that doesn't exist under law to have an ex parte. All right, so now that we know what the procedural posture is, Doug, I know you've been here for a while. Before you go, you got to tell us, because he did release the unredacted, he says it's unredacted anyway, transcript of the ex parte hearings. Now it was long, and I got a copy of it while I was on vacation. And I'll be honest with you, I didn't look at all of it because I was on vacation and it was long. But I skimmed it. But can you sort of hit the high points of what you learned now that you've got the transcript of what happened?
Well, if you want to know the highlights, all you have to do is read my affidavit that I filed in conjunction with my motion to disqualify. Everything that was in my affidavit appears in that transcript. The only thing that I have in that affidavit that's not in the transcript is what occurred off the record. And when I say off the record, I don't mean like talking to a reporter. I just mean the court reporter wasn't there transcribing it. But it's completely consistent with what is in the affidavit that I filed. So you have, oh my gosh, Rachel, have you read it?
I've read parts of it. I get so frustrated reading it.
I mean, it is frustrating and it's upsetting and it's distressing. You've got the judge giving legal advice to the witness.
To Woody or to Copeland.
To Mr. Copeland, some of which is incorrect legal advice. Opining
what?
on
What
the
is he,
scope.
what kind of advice?
Well, he's opining on this. He's opining on the scope of the immunity.
Okay.
And I think incorrectly.
As well as the extent to which he can be incarcerated for this, the length of time. I mean, if you're being told you're going to have to spend a weekend in jail, it's a lot different than 3 years in the Fulton County jail with no protection. And the idea that he would not have protection in the jail is, I think, part of what the thought that the jurors are not seeing any of this. That's a whole nother aspect of this. These jurors are being sent home for weeks at a time. They pick up, I mean, you go on Twitter, you go on CNN, I mean, especially once everything happened with Brian Steele. I know they haven't even polled the jurors, but if you don't think that any of these jurors, all of them, know what's going on.
I think the main thing you see in that transcript is a judge in cooperation with the state hotboxing the witness.
Do it or else.
Coercing the witness to testify. And if the witness refuses to testify, threatening to lock that witness up until every defendant in this case has been tried. He's sitting there, if you can picture it, in the judge's chambers. He's surrounded by 4 deputies, 2 investigators from the prosecutor's office, 1 prosecutor, the judge, the court reporter, and they are all bearing down on him to testify. And I cite case law in some of my motions. A judge is not allowed to coerce a witness. It's horrifying to me. Now, do I think Judge Glanville thinks he did anything wrong? I don't think he does.
And and see, I was going to get to that. And to me, that's part of, I can't get my head wrapped around why Glanville can't or won't conceive of the idea that he's the one that did something wrong. He thinks, from what I did pull out of the transcripts, he thinks that the prosecutor there was no problem with the prosecutor coming to him and saying, I want to do an ex parte with Copeland's lawyer, Melnick, was not actually working in Copeland's best interest. We think that Melnick was in cahoots with the defendants, trying to keep Woody quiet. And therefore, we got to bring him back here in your office in secret without them participating to get to the bottom of it.
And Bumpus was more willing to do that than Melnick. I mean, obviously, they waited for, I'm not saying strategically, but it really worked out for them nicely that Melnick wasn't there to represent his client. And they had somebody who I don't know what Kayla Bumpus says now, but she's friendly enough with Hilton and Love that she was willing to at least engage in that conversation, knowing that none of the defendants were there.
Well, that's what the prosecutors, and I think Glanville, that's the rationale. That's why they think it was okay.
It's not,
because the nature of the allegations being made by the prosecutors, which was that, this witness is being misled by his lawyer in order to benefit these defendants. And so therefore we think you got to have this ex parte. I don't think that makes this ex parte okay, even if all that's true. I think it's a ridiculous assertion to start with, because Melnick can clearly state that the reason that he's, if you don't take the 5th, I'm going to withdraw. That's because Melnick knew, just like what he said in the ex parte, he said he's going to lie. And if a lawyer knows their witness is going to take the stand and lie, the lawyer's got to withdraw.
Yeah, I don't think enough lawyers understand professional responsibility, period.
It's obvious from this case that the ones involved, at least in this ex parte, in particularly the judge, doesn't understand it, or he doesn't care. I don't know.
Yeah. The other thing is, if you look at the reasons that the judge gave in his order of July the 1st for needing the ex parte meeting, they're not sufficient for justifying an ex parte meeting. All the case law he cited has to do with having an ex parte meeting because the defendants are threatening the witness. There's no allegation in the judge's order that this hearing was called because any defendants were threatening the witness. And the reason it's not there is because it never happened. No. So the reasons that are given for needing that ex parte, they just don't hold up.
Ironically, again, I keep saying ironically, they're the ones threatening him, not.
Okay, our colleague, Rich Lawson, Rich is asking, did it appear to either of you guys that Bumpus revealed several attorney-client communications in the transcript of the ex parte meeting?
There seemed to be discussions where she was saying what he's told her. I don't know if Copeland authorized her to do that. Again, I'm not sure she knows what the rules are.
I'm just not going to weigh in on that.
Yeah, look, that's here inside the law. You're welcome to exercise your right to remain silent when it's appropriate.
You're not going to throw me in Rice Street.
No, I'm not going to throw you in Rice Street. Okay. No, and I fully understand, by the way, that this is an active case. There are things that you can't or shouldn't and wouldn't want to get into, and that's perfectly fine. I'll let you decide where that line is, and I won't question it.
Let me mention this order since it sounds like y'all haven't seen it. Judge Krause issued an order that seemed to cross in the electronic filing system in Odyssey with my motion to recuse the Fulton bench. And she issued an order for the state to respond to our motion to recuse Judge Glanville.
I did see that now that you mention it. Yeah.
And their response is due, so keep a lookout. Their response is due 5 p.m. Monday.
All right.
So I'm sure some junior attorney on that case on the state has lost their 4th of July weekend responding to Judge Krause's
I don't know what there is to respond to. I mean, the response ought to be whatever. I mean, I think that if nothing else, to avoid the appearance of impropriety, Judge Krause, I think maybe that this makes sense to have another county do it. Maybe that's the right response. Whether we're going to get that from the Fulton DA's office is another question.
Well, the DA's office, Judge Krause specifically requested, it wasn't on my motion to disqualify Judge Krause or Fulton. She wanted a response on should Judge Glanville be recused.
They're like, no, we love him. He does everything we want, including having secret meetings with witnesses where we can coerce them. What says the state? No one, it'd be really nice if the judge didn't care as much about what the state said. But yeah, some person in the DA's office, it's their job to say that he shouldn't be recused because it was a permissible meeting. And then somebody, hopefully, whoever's going to actually handle this if Krause is out, somebody needs to let the DA's office in Fulton County, as well as the Fulton County bench, know what the rules are. If you don't think that ex parte dynamic transcript is problematic and wrong and is the basis for recusal, if the judge wasn't interested in a conviction, why would he be participating in that?
Well, if they're supposed to weigh in, Doug, on the question of should Glanville be recused? Look, it was the state's idea in the first place to have this ex parte, so they're going to have to say no. They can't admit that it was wrong. Otherwise, then they will admit that there's the necessity for a mistrial with prejudice, meaning they can't retry anybody because the state, eventually, whenever that time comes, the state caused this. And if it's so egregious to require a mistrial, they're not going to be able to retry this case. That's just my prediction where this is going long term.
Yeah, and if you read just the beginning, the first page of the transcript, you see that ex parte hearing is called because ADA Love requested that to be called because for whatever reason, that's none of her business, she felt that Melnick had not been properly representing, doing his ethical duties in representing Mr. Copeland. By the way, defense attorneys are not only allowed to speak to witnesses, it's kind of part of our job.
Yeah, you're expected
to try to do that.
You got to try to talk to them. Look, and here's the thing. Let's just say for a second that this is some kind of legitimate concern that anybody has. What would have been wrong with Judge Glanville saying, look, I can't have an ex parte with the prosecutors and the witness and everybody, but what I can do is I can have a conversation with Jonathan Melnick in camera. And if there's any concerns after that conversation, we'll take it from there. But I mean, if there was any such concern at all that was even remotely reasonable, and I don't think there was a better way to do it than to have this illegal ex parte.
Look, you've read these. The Superior Court rules say when there's an ex parte meeting, the party not invited is supposed to be notified of it and have a chance to respond. Yeah. We were not only not notified of it, we were not given a chance to respond, but I think if you look at this, it was an attempt to cover it up, to keep it a secret. Look how upset Judge Glanville got when we found out about it.
He just came unglued because somebody dared to spill the tea on what he'd been doing. He got caught. Instead of acknowledging that he did something wrong, he dug his heels in. And that's what we kept seeing was he just would dig his heels in on one thing after another thing after another and it's like he's just made the problem worse to the point now that I said it was unsalvageable weeks ago. And if it was unsalvageable weeks ago it's clearly unsalvageable now. I just don't know how he gets, around this. During all this time, you've got all these people that are in jail, been in jail for years now without bond, and they're being held irrespective of anybody's guilt or innocence. It's not about that. It's about the trial and the process has become so unfair, and these people are being held in jail. Their liberty denied them in a process that is just unhinged and so unfair that it's unsalvageable. That, to me, is the key takeaway that folks need to understand is that wrongful convictions happen. Guilty people sometimes go free because things go wrong. When the entire process is so tainted that it's just irredeemable, at some point, somebody has got to just say, we're not going to do this anymore. And the people that are Fannie Willis's office, Glanville, they're not going to be the ones to do it. They are so invested in terms of time and effort and all sorts of other things. It's going to have to be some outside entity, whether it's another judge or an appellate judge or somebody is going to have to tell them, no, it's over for you. This isn't going to go forward anymore.
My motion to disqualify is very narrowly focused. I feel like more of a sniper, right? It's a very targeted attack. But if you want to read a motion that lays out all the bias that the judge has had against the defense attorneys, and particularly Jeffrey Williams, Young Thug, and Brian Steele, read Brian Steele's motion to disqualify, because he does not limit it the way I do. My motion is very limited, just focused on the ex parte hearing, and Brian Steele complains about a lot more than that in his motion. Read his motion if you want to see everything that's going on in this case and get riled up.
Yeah, I've seen it, and you've just given me an idea. Maybe that'll be my next video or live stream, because look, there's a lot there. But no, look, when all this is over, Doug, and I don't know, by the way, how you guys do this, because you've been at it for so long. I just don't understand. I can't really get my brain wrapped around it, but I owe you drinks or something, buddy. We got to all get together and break this down, because I think, I have so much respect for what you guys are doing, just being there day in and day out, stuck in that courtroom in this one case. It's I think it's awesome, and it's inspirational.
I would say.
Thank you very much.